Welcome everyone to the IAPP web conference, the latest insights on managing cross-border data transfers, sponsored today by Security. My name is Jordan Hardy, Programming and Speaker Specialist here at the IAPP, and I'll be your host for today's program. We'll be getting started with the presentation in just a minute, but before we do, a few program details. Participating in today's web conference will automatically provide IAPP certified privacy professionals who are the named registrants with 1 CPE credit. Others who are listening in can apply for those credits through an easy-to-use online form on our website. I also want to let you know that a recording of this program will be available in your My IAPP, My Purchases, My Recordings portal within 48 hours. So what that means is you sign into your account at the top right of our website, and then you go to My Purchases and My Recordings. You'll also find the PDF of the slides there. Please feel free to post any questions you have for the panelists in the Q&A area at the bottom of the screen specifically throughout the program, and there will be a designated Q&A portion in the last 10 to 15 minutes. So now onto our program. I'd love to introduce today's panelists. First, I'd like to introduce Helen Huang, Director of Product Management at Security. Helen, welcome. Thank you for joining us. And could you tell us a little bit more about your current role and prior experience?
Absolutely. This is Helen from Security. Security is a company that helps businesses meet their data security, privacy compliance obligations. I've been in the data privacy space for a little over 10 years. I'm currently on the product team, mainly focused on assessments and consent. So I'm very excited to be here with my friends Josh and Ricky. Thank you.
Amazing. I'd also like to introduce Josh Harris, Director of Global Privacy Initiatives at BBB National Programs. It's also a pleasure to have you, Josh. Can you tell us a little bit more about your background and current role?
Thanks. Well, currently, as you said, I'm the Director of Global Privacy Initiatives at BBB National Programs. We are, among other things, an accountability agent in the APEC Cross-Border Privacy Rules and Privacy Recognition for Processor Systems. That means we're a recognized certifier. We're also an independent dispute resolution mechanism in the Privacy Shield frameworks, and we'll be hearing a little bit more today about the status of those and what the future of that might look like. In addition to that, we run several other privacy programs, but of course we sit within the broader BBB National Programs, which is an organization 501c6 that is designed and developed to enhance consumer confidence in business.
Love it. Thank you so much. And to round out our panel, we are excited to have Ricky Skripnik, Manager, Legal and Compliance at Aurinia Pharma. Ricky, can you tell us a little bit more about your current role and background?
Yeah, my current role is obviously manager, and then I also run the privacy program at Aurinia and function as their DPO. So a lot of good data cross-border transfer experience there. And then as a background, I've been in privacy only for a couple of years. Otherwise, I was about to say what I've been doing. Law student, current time, work in the daytime, normal busy stuff. So it's all good. And I finalized my CIPPE yesterday. So it's busy times.
Love that. Perfect. Well, we're so excited to have all of you. And with that, I will hand it over to our panelists.
Thank you, Jordan. So again, very excited to be here to talk about the cross-border transfers landscape. It's been very dynamic the last couple years, and especially recently with the Transatlantic Framework announcement. And across the last couple years, also other countries such as China has set forth their own cross-border requirements. So more and more, as companies want to maintain their business continuity, it's extremely important to handle this and approach this operationally, not only from a technological perspective, but also a framework perspective as well. And that's why I'm so excited to have Josh and Reggae here, who can really provide the thought leadership and actionable insights into how to handle those two approaches. So without further ado, I'd love to hand it off to Reggae to kind of talk about what is important to highlight here in the cross-border transfer development, what's important to highlight for the audience here to follow, and share her thought leadership, with regards to what's happening in the Canada, in the EU. So Reggae, without further ado, do you want to kick us off?
Of course I will, and I would love to start with Canada, where I'm currently located. And looking at Canada right now is kind of like it kind of feels like we're in kind of a drought phase a little bit for privacy, but you can kind of see the storm coming in on the horizon. And when I say it feels a little bit like a drought phase, it's because it doesn't seem like there's a lot of developments going on. And especially when you look at the last year's, I was about to say death of Bill C-11 that was supposed to come in and basically reform and put in place good privacy measures for Canada. And then that died back in December. Then I think we're a little bit like sad when that happened, but I think there is hope to be had. And I feel also like there is a move towards wanting to reform Canada, both provincially or federally, into a GDP like environment, if you can say so. And why do I say that? Well, the Canadian Privacy Office Commissioner, or Commissioner of the Canadian Privacy Office, published his report for 2022-2023, kind of looking forward and what's hopefully to come. And in that, obviously, he mentioned BC11, but he also mentioned that despite of that being put in a box and hidden away somewhere, there is a desire and there is also some traction to reintroduce a bill again and get some reforms both into the public, but also the private sector. So even though it may look a little bit dry out there right now, there is definitely hope to be had for what's to come. And I think we're going into a very exciting year. And that opinion of the Canadian Privacy Commissioner was also voiced by the BC one, and obviously sitting in BC, that's the man I listen to, who also in the Privacy and Security Conference earlier in this month basically said the same thing, which is obviously we're all sad that that bill didn't get passed, but there is a desire to move ahead. And a good example there is Quebec, obviously coming in where their new Bill 64, which when you look at it, for example, on cross-border data transfers, implemented some GDPR-like familiarities for us regarding having to do PS when you do transfers, ensuring that there's contractual requirements in place, but also having to look at the adequacy of the countries you're sending to. They didn't really specify what that meant as such, but one of the interesting factors there is actually that Quebec had, when they made that bill C-64, to discuss having a list of adequate countries. And all of these concepts obviously sounds very, very familiar, but that piece of it didn't go through because there might be some political things underneath that decision, obviously. So there is that desire to move, which is also kind of reflected by the BC PIPA committee, it's a committee basically reviewing PIPA and see how that is. And that committee in itself called GDPR the golden standard for privacy. And there is a wish to also reform that law into something that looks more GDPR-like. So hopefully on the horizon, we're looking at a lot of reforms, a lot of good stuff that's going to move us into a GDPR look-alike environment, hopefully a bit easier on the adequacy part. So really good for data transfers. But PS is definitely here to stay. And I think that is also voiced when you look at the guidance that was released by the BC Privacy Office this month, which is basically guidance on the on FIPA. And what happened basically, FIPA is a what is that? That's the Freedom of Information and Protecting Privacy Act. And that the act previously had a lot of resident rules. So it was really hard to move data out of Canada. And what happened with COVID was that COVID basically punched Canada into having to acknowledge that, yes, we should have more ways to transfer data out of the country so that we can advance faster technology-wise. So that's super great. And basically they came up with this guidance. And what do you see in this guidance? You see more PS. You have to make those assessments every time you do your transfers. What do you also see in this guidance? Well, you not only do you have to do your PIA and ensure you have the contracts and all of that good stuff in place, but you also need to do an assessment of the legal framework. And basically the examples they use regarding legal frameworks is that if the contract doesn't have privacy laws, then they don't have protections. If they don't respect the rule of law, it's also kind of a no-go. And then obviously you have to ensure that the law has adequate protection. So it's interesting. They didn't go into didn't go a lot into what's it called details on what adequate is, but at least there is some movement here where we can see definitely on the cross-border transfer piece assessments are here to come, or PS are here to come, and obviously having to be critical of where you're sending your data. So with that, I'm going to jump over to the UK, or United Kingdom, not to be forgotten. And I think one of the biggest advancements we've seen there, and I was very lucky that this came out like 10 days ago, is that the International Data Transfer Agreement came into force here on March 21st. And why is that exciting for us? Well, it is because the International Data Transfer Agreement is basically the UK's version of the, I call them the new SCC, but that's the current SCC for Europe, obviously. So if you're doing transfers and you're only having to hold personal information from people from the UK, well, this is your new agreement to go to. And rest assured, it's a wonderful thing to be able to use. It's set up with tables. I was about to say there's editable parts. There's of course also mandatory parts. And obviously it also takes into account some of the Schrems stuff, basically where if you look at the European SCC, well, you can't really incorporate those extra safeguards that you need in some instances. But the UK version actually made space for those. So there's I was about to say there's good news there. And then obviously with that agreement, they are also still keeping in mind that we are all hopefully working in a more global framework. So we also needed a solution that we can combine with especially GDPR. So that's where the UK addendum came into place on the same day. And what is that? Well, very easily, the UK addendum is basically just an extra 9 pages that you will add to your European SCCs, and boom, now you're able to send both your data from Europeans, not that UK people, not Europeans, they're still there. You know what I mean? You're able to basically utilize both the GDPR rules and the UK GDPR in one go. So it's a great tool that they came up with. And also they did ensure to highlight some of the downsides of the current SCC. So I definitely would advise everyone who has to deal with UK, go and read all the new guidance that probably will come out in the coming months. And with that, obviously, there's also some transitional provisions of this whole thing. So obviously right now, you are allowed to use the old European SCCs in the UK, and you can basically use those up and until December of this year, and they will remain valid until September of 2024. So you kind of have like a fun discrepancy, because obviously in Europe they would like us to phase out the old EU SCCs before the end of this year. So something to be aware of: if you start new transfers, obviously you should use the new IDTIA or the addendum. But if you have things ongoing, you can keep on to it. But just be aware with that little piece with the new SCCs actually having to be coming. They are into place, but the old one should at least be phased out by the end of the year. And that's kind of my gateway into talking a little bit about what's happening in Europe, or from a more GDPR-like perspective. And I think it's been, from a cross-border perspective, it's been a ride for quite some times. Like obviously Europe or the Commission is very, very busy with everything from the new Digital Markets Act and antitrust stuff. There's some delicious new guidance also on what do you call it, on the whole like cooperation procedure between the lead supervisory authorities and all that good stuff. But I think from a cross-border perspective, the Google Analytics cases that's been coming out as part of that 101 cases from NOYB has probably given most of us a little bit of sleepless nights, because basically what happened there is that these were the first test of the additional safeguards that has been implemented by Google to try to convince that transfers to the US is still okay. And Google basically implemented both organizational, like more transparency rules to try to open up so the data subjects would know whenever the data was being accessed. That wasn't enough. They tried to implement technical measures such as encryption, but there was some questions about when encryption had to be had, and also you have to hand over the key. So therefore, didn't really fly. And then from a contractual perspective, the measures they implemented there, well, the contracts are not going to fix anything if the legal framework you're basing them on is not adequate, to use a nice European term. So unfortunately, all of those extra safeguards fell through. And I think all of it, it left all of us feeling a little bit like, okay, either I stop all my transfers right now, or I start collecting consent, which I can't collect through a cookie dashboard in the bottom of a web page. I really have to get that explicit good consent to do these transfers, or I sit down and I wait and see. And for us, for everyone who's been sitting down and just taking a deep breath and wait and see, I think it was a sigh of relief here a couple of weeks ago when the new transatlantic data flow agreement actually got announced. And that obviously is super exciting that they have agreed in principle, but obviously there's still a long way to go, because what they agreed to is basically there has to be implemented some safeguards that ensures that whenever intelligence activities can go in and look at data, that they can only do so under necessary and proportional measures. So restricting that kind of access, and then also the implementation of a data protection review court that can basically be this redress system for Europeans in case their data gets accessed. And it's a little bit, it's going to be very interesting to see how these two things are going to be basically added into law, because before the US, because the adequacy decision from the European Union cannot happen before it's actually been implemented. So I honestly, personally don't have a lot of experience with how long it takes for the US to implement such, I would assume, big reforms in laws. But before, like, even if they do it by the end of the year, we're probably looking at least another 6 months before the adequate decision could come into place. However, looking at the European Commissioner who were making a talk on some other matters early in the month, he did actually give a little bit of a sigh of relief there, because he said there won't be any changes for companies in the list of obligations as when compared to the privacy shield. So hopefully, fingers crossed, this principal agreement is going to push us into where we need to be. And hopefully in the future, the transfers to the US is going to kind of even out. And even if you use the SCC's Azure framework, well, if they fix this, it's going to fix a lot of things, both for Shield users or for SCC users. And I think that's a really good gateway to kick it off to the next one.
All right, thank you very much. So now hopping back over the pond to the United States, I want to take a look at some trends that we're seeing in state laws, but then also the way that some of these international frameworks, and Privacy Shield being one of them, might actually facilitate broader intrastate compliance over here in the US. So next slide, please. So for purposes of this conversation today, I wanted to take specifically a look at Virginia, Colorado, and Utah. So that would be the second, third, and fourth states in the United States after California to have passed statewide privacy laws. One of the things that you'll notice in these three laws is structurally they are very similar. Now, what gets a lot of publicity and a lot of attention in the news is when it talks about private right of action or the lack thereof. In the instance of all three of these laws, it's the Attorney General and only the Attorney General that is charged with enforcing the laws. There is no private right of action. But when you dig down into the actual consumer rights that are afforded and the according company obligations that are outlined in these, they're very similar. So let's take a look, for example, at just some very basic elements in the consumer rights structures of these laws. Now, they're in different places and they're worded slightly differently. But one of the things that I find very heartening is that they are by and large very similar. So when we look, for example, at VCDPA, that's the Virginia Consumer Data Protection Act, a controller shall comply with an authenticated consumer request to exercise the right to confirm whether or not a controller is processing the consumer's personal data and to access such personal data. If you look over in the CPA and then you look over to the UCPA, you see that there are very similar structured rights afforded to those citizens in those states. What does this mean for you as a business that's operating obviously across more than one state? The idea is that you can put together comprehensive privacy policies and practices that can meet the obligations of all three of these laws pretty readily.